Why did you write the memo?
I wrote the memo because starting, I think, in June of 2017, there were many news reports, and I had no facts, and none of us really outside the department have facts. But I read a lot of news reports suggesting that there were a number of potential obstruction theories that were being contemplated, or at least explored. One theory in particular that appeared to be under consideration under a specific statute concerned me because I thought it would involve stretching the statute beyond what was intended, and it would do it in a way that would have serious adverse consequences for all agencies that are involved in the administration of justice, especially the Department of Justice. And I thought it would have a chilling effect going forward over time. And my memo is very clear that is the concern that was driving me. The impact, not the particular case, but its impact of a rule over time. And I wanted to make sure that before anyone went down this path, if that was in fact being considered, that the full implications of the theory were carefully thought out. So I wanted my views to get in front of the people who would be involved in, and the various lawyers who would be involved in those discussions. So I first raised these concerns verbally with Rod Rosenstein when I had lunch with him early in 2008, and he did not respond and was sphinx-like in his reaction, but I expounded on my concerns. And then I later attempted to provide a written analysis as follow-up. Now, I initially thought of an op-ed, and because of the material, it wasn't working out, and I talked to his staff, and I said, you know, I want to follow up and send something to Rod in writing, but is he a one-pager kind of guy, or you know, how much will he read? And the guy said, he's like you. He doesn't mind wading into a dense
Don't you think
memo.
President Trump is a one-pager kind of guy?
Excuse me?
President Trump is a one-pager kind of guy.
I suspect he is.
Okay, just remember that. Go ahead.
Yeah. And so I provided the memo to Rod, and I provided it, distributed it freely among the other lawyers that I thought would be interested in it. And I think it was entirely proper. It's very common for me and for other former senior officials to weigh in on matters that they think may be ill-advised and may have ramifications down the road. For example, just a few months before that, I had weighed in repeatedly to complain about the idea of prosecuting Senator Menendez. I think I made 3 calls. I think it was 2 to Sessions, to AG Sessions, and 1 to Rosenstein. Now, I didn't know Senator Menendez. I don't represent Senator Menendez. No one was paying me to do it. And in fact, I don't support Senator Menendez politically. But I'd carefully watched this case. My friend Abby Lowell was his defense counsel, and it was very much like a line of cases that I had been concerned about when I was AG, and so I was watching it, and I thought the prosecution was based on a fallacious theory that would have bad long-term consequences, and so I freely weighed in at the department. And I did so because I care about the rule of law. And I want to say one final thing on the rule of law because it picks up on something you said, Mr. Chairman. What is the rule of law? We all use that term. In the area of enforcement, I think the rule of law is that when you apply a rule to A, it has to be the same rule and approach you apply to B, C, D, and E, and so forth. And that seems to me to suggest 2 corollaries for an attorney general. The first, that's why we don't like political interference. Political interference means that the rule being applied to A isn't the rule you're applying to A. It's special treatment because someone's in there exerting political influence. The corollary to that, and this is what you're driving at, Mr. Chairman, is that when you apply a rule, when a prosecutor is applying a rule to A, you've got to be careful that it's not torqued, especially for that case, in a way that couldn't be applied down the road, or if it is applied, will create problems down the road. And I think the Attorney General's job is both. It is both to protect against interference, but it's also to provide oversight to make sure that in each individual case, the same rule that would be applied broadly is being applied to the individual.
Thank you, Mr. Chair.